Eagle Entertainment, we're about to react to someone lawyer trying to argue with the judge. And like, if you haven't watched a video like this, I just learned a lot. I just watched it, and the argument, I'm not gonna tell y'all what it was about. Y'all just gonna have to stay tuned. And if you like this video and if you like this channel, please subscribe.
On December 3rd, 2024, felony probationer Marcolin Zenon was arrested in Harris County, Texas on an open warrant. Mr. Zenon was also charged with interference with public duties for allegedly refusing to place his legs and feet inside of a patrol vehicle and straightening his legs out to prevent the officer from placing him in the vehicle while being arrested. Attorney Gregory Cioros was appointed as Mr. Zenon's counsel, and on December 5th, 2024, Judge David Fleischer of Harris County Criminal Court in Houston.
First off, let's start the way he looks.
Harris County Criminal Court in Houston, Texas held a probable cause hearing to determine if there was sufficient evidence to charge Mr. Zenon with interference.
We gotta be
24 officers were
aware
dispatched to the HEB located at 4955 State Highway 6 regarding concerns in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed
located.
what?
They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with at the intersection.
Okay, they saw.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a...
Plus, it would because he, if I'm right, he would...
Officers commanded to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward the officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
My understanding is it's an
And it was an
older
open
case.
at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going plank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. Like, and they're
I understand
and they're a mile, 0.1 mile away from the location. For what?
Okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there. They start to talk to him, and I guess at that point says, "Hey, man, I'm gonna slap her." So at that point, I mean, that's what we have.
Okay.
Right? Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant, and then they find there was something else. Was there another warrant that you said?
It's the aggravated assault with Judge. I also would like to point out that
But then they end up putting him in the car,
You're gonna
and at
get
that point,
charged
he
with
basically
that.
just
What did he
goes
think
blank like this
everything was
for them
driving
being
and
unable to
happy?
effectuate an
He's
arrest.
not gonna get charged.
And
He's gonna
Judge,
get
You don't think
charged.
that's an interference?
I don't. I mean, I think the intent.
in the car and he go blank. Like, he's telling him, like, I'm not gonna tell y'all nothing else. I'm not gonna act right with y'all. He didn't already want to put his legs in the car.
Of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, all right. Let's pull up the code.
Intake could have taken some other things, but.
Well, certainly, they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know?
But they didn't
hit.
They took the one that I do not believe applies here.
Let's read the code.
Okay.
Let's see what the code says, because, you know, there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can, you're right. It could have been like a resisting,
Comment if
you know.
this is crazy
but-
to y'all, because this is crazy to me.
Get the QuickBooks mobile app. Simply snap photos of receipts, tap, and sort transactions automatically.
The law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts,
Yeah,
impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
that.
that the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
Mr. Cioros argues that the interference statute is unconstitutionally vague. The void for vagueness doctrine is a principle under the Due Process Clause that requires criminal laws to be clearly defined. As the Supreme Court explained in the 1983 case of Colander versus Lawson, a criminal statute can be deemed unconstitutionally vague if it is so unclear that ordinary people cannot understand what conduct is prohibited, or if the lack of specificity encourages arbitrary and discriminatory enforcement, thereby conferring on police a nearly unlimited power to arrest and charge citizens with a violation. Accordingly, Mr. Cioros is essentially arguing that the interference statute is unconstitutional because it does not clearly explain what is illegal and allows officers to enforce the law arbitrarily due to the broad range of conduct that could potentially be covered under it.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1 miles.
gives him a wall between his arrest. I feel like if he didn't have that warrant, he would not be arrested.
The warrant. They didn't know about the warrant till after.
It's a felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing.
Mhm.
I mean, that's what they were investigating.
And the witnesses all
They
described
put him,
the
I guess,
defendant.
did they put him under arrest at the time when he said that he was making that threat?
And with being
He should never said that. He's just putting himself in a deeper, way deeper hole by saying, "Oh, I'm gonna slap this girl." Why would you say that? Like, and the police been called on you multiple times about this in one situation, even makes.
I mean, did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist.
it-
That's not
it
interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. It's if the officer didn't put in the report. He's not saying in the dim summary, you are under arrest.
Well, I mean, it's
Okay, well, I mean, but so
I mean,
this
we
is,
don't know. I mean,
okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is,
we also
And
don't
yes.
have the offense report
We
yet,
don't
I
have
Judge.
don't
Judge,
care. I
he
mean,
was in
but
the
I think that
process.
there's enough, he's under, he places him in custody.
What they're saying is right. I ain't gonna lie. He did what he did go blank. So they have no choice to arrest him.
Right? He's going to
Like,
arrest him, starts
they're
putting him in the
like,
car,
okay.
and dude goes plank.
I know, but I don't have the video.
I
I've
mean, I
shared the
think that-
videos with
remember-
you.
Right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car.
We are gardeners.
Tell me what y'all think about this crazy video. I think everything he done is leading up to this is making sense. But you can comment if it don't make sense. It's your opinion. If you wanna see more videos like this, subscribe, cause I will be posting more videos like this.